Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to have a look at a short video clip. It's a surveillance video from the eBlue Esports Stadium, it looks like. And so I want to go through this. It's about a minute long, although it's going to be longer when we're done with it because I'm going to stop it at various points just so that we can examine legal issues that come up. This is a particularly interesting one in terms of self-defense, defense of property issues. So let's have a look here. So here we've got the, you can see why they'd call it the eBlue. It's very much blue in decor. So it just starts out, all right, so we see this individual walks in and right away we can see that the store owner is taking notice of that. The store owner is sort of getting up. There's no audio to this, so we don't know exactly what's being said, but you can see that there's an interest being taken here. And did you catch that? He sort of walks up and he makes the gesture. It's pretty clear from body language and demeanor here what he's doing is he's telling this guy to get out. That's the long and short of it. So right now what we have here is that it seems that the store owner or manager or whoever this individual is, but somebody who appears to have sort of decision-making power over the store is asking him to leave, and he's saying no. He's saying not happening. So that kind of triggers some important legal things because at this point, if he's not leaving, he's a trespasser. He's being asked to leave. He's not doing so, so now he's trespassing, which puts him in a much weaker legal state. And so we'll see sort of how that applies. Now, right there, what we see is a little bit of physical contact. So as a starting point, that is an assault. And by that being an assault, I mean the guy in the gray shirt, when he rests his hand, sort of as a starting point, it appears that that's non-consensual physical contact. Now, the issue is going to be, does he have a defense in terms of defense of property, defense of person? Defense of person doesn't seem to apply at this stage, but defense of property might. And I'll go through the defense of property things here. For right now, I'll just say that it looks like he's probably acting sort of reasonably in defense of property to remove a trespasser. So let's continue here. And so what we see here is that this guy is immediately confrontational. He's not leaving. He's presenting sort of an angry, confrontational, aggressive front. He's not happy about this at all. We can see that the other person in the store has gotten up and is now circling around. And we've also got this other guy who's just showed up. So let's have a look at this other guy too. All right, so the sharp-eyed viewers, especially sharp-eyed American viewers, might have just noticed what he said on the table. That's not a decorative vase. That's a bong and a grinder and something else, but almost certainly part of that whole package. Now, in terms of the legal implications of that, absolutely nothing. He's, you know, it's legal here, so the bong is legal, the grinder is legal. The marijuana is probably legal, or at least it's going to be very difficult for anyone to prove otherwise. So that's not a big deal. I don't think that's going to weigh in one way or the other here. But let's keep our eye on him for just a second here. You see what he did? I'm not sure if you caught that. You need to be a fairly sharp-eyed sort of viewer. He transferred something from one pocket into his hand, and you can see him, I'm just going to switch camera here. You can see him sort of adjust it in his hand. Well, why is he doing that? Well, it's something along these lines. He's adjusting it in his hand to bring the spray nozzle to get it ready to go. So be aware of that. And let's keep going here. I'm just going to switch us back. So he's got that in his hand. Now, right here, if you're sharp-eyed, what you can see, and I'm going through this fairly carefully. I've actually watched this about 5 or 6 times at this point. The reason why is because I'm watching this as if it was defense disclosure. I'm trying to pick up on everything that's going on. And if you see the guy in the sort of the Adidas jacket there, he's noticed what's in Plaid Jacket's hands. He spotted that, and he's not happy about it. So at this point, he's clearly seen that there's a weapon that's in play, and let's look at his reaction. So he comes up and he's in his face. He clearly looks down towards the hand. I suspect what he's saying is something along the lines of, "You gonna spray me with that? What are you gonna do? What are you gonna do?" That kind of dialogue. But again, we don't have audio. All we've got is the video, so all we can do is guess. But it's clear that he's seen that, and you can see the focus, his focus changes from his dispute being with these the two store clerks to with the guy in the plaid jacket. This is a very common thing. If you bring out a weapon, you should expect that suddenly you're going to be the main event. So there is some danger to that. But let's sort of see what's going on here. So he's still very aggressively posturing, getting into his personal space. There's some reaching around that we can't see because there's something, probably a fridge or something in the way. But he's very much in, in this person's face. He's confronting him. He's angry. So there's a clear element of physical threat there. And now we can see the physical altercation. Guy in the Adidas jacket takes his first swing. He takes, an initial jab there. And then we can see the guy in the plaid jacket pushes him back and sprays. And we see there's an immediate effect to the spray. The guy in the Adidas jacket sort of steps back. He's recovering. He's dealing with this. Now, I've heard from corollary sources that this is dog spray as opposed to sort of human spray. And so it's going to be at the weaker end of things. So let's have a look here. So he does not like that. He sort of staggers back. He's wiping his eyes. He's still angry. He's still sort of, gesturing with threats, and a couple more little puffs and off he goes. Now, the other thing we can see here is the other people in the store are reacting. You can see that this is affecting other people. This is another thing to consider with respect to any sort of, pepper or OC sprays, which is that they affect other people in the area, and including yourself. There's lots of people who have been disabled in terms of an aggressive confrontation by their own pepper spray, especially if, wind is a factor or the like. This is not going to be a very windy scenario because it's a small enclosed space, but people clearly, have some issues. So let's talk about all of this here. Right at the outset, as mentioned, the guy in the Adidas jacket becomes a trespasser when he appears to be asked to leave and he doesn't. And so, in my view, the force that's applied here is probably going to be viewed as justified, simply because the initial force, the initial hand tap, is very minimal force, and it's just for the purpose of, that we can see, of getting him out. So if we look here, I'm going to just go through a little bit of the legislation. I'm not going to go through a whole lot of case law on this, because otherwise this video would be much longer than it will be. But we see defensive person. So a person is not guilty of an offense if A, they believe on reasonable grounds that force is being used against them or another person, or that a threat of force is being made against them or another person. B, the act that constitutes the offense is committed for the purpose of defending or protecting themselves or the other person from that use of or threat of force. And C, the act committed is reasonable in the circumstances. Reasonable in the circumstances is a big deal. There's a lot of argument over that. That's going to be, that's usually where sort of the action is in litigation on this. Now, factors. So the Parliament has identified a number of factors. So in determining whether the act committed is reasonable in the circumstances, the court shall, which is must, consider the relevant circumstances of the person, the other parties, and the act, including, but not limited to, the following factors. So 1, the nature of the force or threat. 2, the extent to which the use of force was imminent and whether there were other means available to respond to the potential use of force. C, the person's role in the incident. D, whether any party to the incident used or threatened to use a weapon. E, the size, age, gender, and physical capabilities of the parties to the incident. F, the nature, duration, and history of any relationship between the parties to the incident, including any prior use or threat of force and the nature of that force or threat, and any history of interaction or communication between the parties to the incident, the nature and proportionality of the person's response to the use or threat of force, and whether the act committed was in response to a use or threat of force that the person knew was lawful. So as an example of lawful force would be a police officer is engaging in a lawful arrest and you decide to fight them. That's what that factor can refer to, or other, uses of force. And it's no defense if the force is used or threatened by another person for the purpose of doing something that they are required or authorized by law to do in the administration or enforcement of the law, unless the person who commits the act that constitutes the offense believes on reasonable grounds that the other person is acting unlawfully. So that is an exception that basically says you don't have self-defense against lawful use of force in the administration or enforcement of the law. So you can't just defend yourself against a police officer unless you have reasonable grounds that the officer is behaving unlawfully, which can be a risky scenario. But you can't just say, hey, he wants to handcuff me, so I'm going to fight him. Now, defense of property. Person is not guilty of an offense if they either believe on reasonable grounds that they are in peaceable possession of property, or acting under the authority of or lawfully assisting a person who they believe on reasonable grounds is in peaceable possession of property. And B, they believe on reasonable grounds that another person is about to enter, is entering, or has entered the property without being entitled by law to do so, is about to take the property, is doing so, or has just done so, or is about to damage or destroy the property, or make it inoperative, or is doing so. And C, the act that constitutes the offense is committed for the purpose of preventing the other person from entering the property or removing that person from the property, or preventing the other person from taking, damaging, or destroying the property, or making it inoperative, or retaking the property from that person. And the act is reasonable in the circumstances. And again, you're probably going to be looking at the same criteria for reasonability here. So looking at this one, when we consider the initial contact, that initial sort of hand touch, it's very difficult to see that this wouldn't fall under defensive property. I don't think the Crown would, proceed with charges on that one, because what we have is that this person is on the property and he's no longer entitled to do so. And it seems that they're attempting to remove him. So I can't see the Crown wanting to proceed with charges on that. But next we get into some more complicated issues there, because we see this altercation going on. And this one is going to raise issues of both defensive property and defensive person, because this individual in the Adidas jacket is giving indications, A, that he's not leaving the property, and B, that he might respond violently. Now, we don't know several of the things that are key in terms of the factors. I don't know what the nature and duration and history of any relationship between these parties is. We can see that the store owner immediately gets up to throw this guy out. From that, I suspect that there was probably some sort of prior altercations, prior issues, but we don't know that. I mean, this could be a human rights complaint kind of situation. There's all sorts of possibilities, and that's going to weigh into things. However, we can see that there's an immediate sort of aggressive confrontational stance. However, once the other person comes in and, has the, what I'm told is dog spray. I'm not sure if that's the case, but, once that person, produces that, we can see that there's an aggressive response to that. And this individual might also try to claim that there's a defensive person issue, because now he's saying, I'm being menaced with a weapon, and therefore, I'm defending myself. I suspect that with respect to the guy in the Adidas jacket, the court would say that the reasonable response from his perspective is to leave. He's there, he's been asked to leave, he's a trespasser, he's facing this weapon. What is the reasonable response? You leave. In terms of duties to retreat, I would say that the court is probably going to say, yeah, you did have to back away in a situation where you're no longer even entitled to be there at all. So that, I don't think he'd have a very good good defense on that. But in terms of the pepper spraying itself, that one could go either way, to be honest. I suspect that a court would find that it was either reasonable under the circumstances, or that the Crown hadn't proved unreasonability, because the Crown bears the burden of proof beyond a reasonable doubt of proving that you're not reasonable in the circumstances. But, you know, it could go in any direction. You never really know for certain what the court is going to do. And this is a situation where I think it's pretty clear, but it's not 100% clear. For example, when we look back at our factors here, the extent to which the use of force was imminent and whether there were other means available to respond to the potential use of force. The court might say, hey, listen, there were 3 of you at this point. You know, couldn't you have waited and seen? Whether any party to the incident used or threatened to use a weapon. The only party here that seems to be using or threatening to use a weapon is the guy in the plaid jacket with the pepper spray. Size, age, gender, and physical capabilities of the party to the incident. The guy in the Adidas jacket does appear to be fairly large, although the plaid jacket guy seems to be a bit larger. So it's hard to say for certain, but I don't think a court is going to say, listen, you had to get into a fist fight with this guy. This to me seems to be an entirely reasonable response here. But the other things we come up with here is the use of the pepper spray. Because if we're talking about something like this, you know, this is dog spray, then we're talking about something that he's legally entitled to own. It's not illegal to own dog spray, but there may be questions, for instance, of whether or not this individual possessed that for purposes dangerous to the public peace. Does he have this for dogs, or does he have this for people? If he has it for people, they might be inclined to find that that was possession of a weapon for purposes dangerous to the public peace. They might also charge him with carrying a concealed weapon, because I'm not sure if we could see that dog spray on his person until he brought it out. I certainly didn't, but the video is not a great view of that. So they could potentially charge him with those issues. In terms of whether or not they'd get a conviction on the, particularly on the possession for purposes dangerous, that would largely depend on whether or not he opens his mouth. Because if he says, yeah, I carry this around because, you know, look at that guy, there's people like that all over the place, you know, angry, dangerous people who, you know, might threaten me, so I carry this dog spray so that I can spray those people. That might be him easily talking himself into a conviction. Again, the important thing is keep the mouth shut. It's, you know, your mouth is the least helpful part of your body when you are in custody or facing police scrutiny over something like this. The other thing is looking at the spray. That one seems to, the video sort of says that it's dog spray, but the spray pattern seems more consistent with what I've seen from people sprays. So I'm not clear. This might be people spray. And in that case, he could be charged with possession of a prohibited weapon, and that's a lot of trouble. So, you know, I can't say for certain. I think that the use of force here is good. The weapons issues are, you know, up in the air. There's not enough information to know. The old joke in law and in law school is that the answer is always, it depends. And that applies here. I say that with a really superficial overlook at just this video, without anything else, it looks like, in my view, these individuals would likely be acquitted, but I can't say for certain. It looks to me like it's probably a good use of force. Again, the weapons issues are a little more dicey. But the other thing is, if you were the Crown prosecutor and you were looking at, you know, public interest, there's different directions that they could go. They could say, listen, you know, this guy who is clearly sort of an aggressive trespasser was removed. You know what? Let's just call it a wash. But they could say, hey, you know what? We don't like this plaid shirt guy. We don't like that he's walking around with some sort of weapon. We want to deal with that. And that'll really depend on the personality of the Crown prosecutor involved. And it's hard to say. There's other factors that we don't know. For instance, we don't know if any of these people involved have a criminal record that can really weigh into decisions on Crown discretion. You know, if the Crown's thinking, hey, do I want to cut this guy a break and not charge him, you know, over the possession of the spray? They're a lot more likely to say, you know what, we're going to let this slide if you don't have a record than if you do. Things like that. So anyway, I know that's probably not super satisfying, but that is the way the law works, unfortunately. I hope that this was a little enlightening all the same. It's kind of shows a self-defense or defense of property kind of scenario. It's just an interesting sort of little altercation. Anyway, thank you for watching. I want to thank my Patreon subscribers at the $50 level, Demo, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Toronto Airsoft. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt. I'd also like to thank my $10 Patreon subscribers who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge, and see you next time.